Good morning. You're Deanna Paul?
Yes, ma'am.
And Ms. Paul, this is your initial appearance in cause number 25, DCCR 1792. You're charged with a third-degree felony offense of stalking, and that's from October 3rd.
At the outset, the defendant faces a third-degree felony stalking charge. This classification is a serious matter. In situations like this, judges immediately assess potential risk factors, patterns of repeated conduct, and whether the accused presents a continuing threat. Early impressions during such hearings often carry significant weight.
2020, stand up. What's the matter?
Nothing. My allergies.
Okay. I test you this morning. You gonna have anything in your system?
No, ma'am, but I just sneezed back there.
Okay, let's double check it. Have a seat in the jury box, please. So, Ms. Paul, I received a note that you refused to take a drug test.
Yes, ma'am, because I leaned against the thing. I just finished sneezing back there, and I felt like I was being singled out. I know I have alcohol in my system.
So
From the night before.
So let me explain. If you don't test,
Mm-hmm.
and let me see what is or is not in your system.
The tension increases quickly at this stage. Refusing or delaying a drug test while under court supervision raises immediate legal concern. Even hesitation may be interpreted by the court as noncompliance. In bond proceedings, perception can influence decisions as strongly as direct evidence. The defendant must choose between immediate compliance or asserting legal objections.
Then I'm going to assume that you're positive,
Okay.
and I will raise your bond for sure, and you'll go to jail.
Okay.
So do you want to take the test and let me see what's in your system?
I don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're going to give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm going to get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the drug test, then you're refusing a court order, and I'll raise your bond and you'll go to jail. Then you'll have an attorney come visit you in jail, and they'll go over all of the charges. If you want to take
So
your
I can
time,
bond out.
yeah, your bond's going to be raised though.
But could I bond out today? That's what I'm asking, because
You don't know what I'm going to set your bond at
Because I'm
yet.
trying to go to work.
Well, then you should probably take the drug test.
Let's try.
Because the more you refuse to do it, the more concern I have, and probably the higher your bond's going to be.
I'm just worried about getting back to my kids and going back to work because
Then take the drug test. So either there's something in your system other than
I have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your system.
Just weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I can sit and see if I can pee.
Go try. Justin Wallace with Mr. Lewis. Okay, so you've refused again.
I didn't refuse. I told them that I couldn't go. I
Well-
refused for the sec.
This marks a decisive shift in the hearing. An admission of marijuana use combined with refusal-related concerns may be viewed by the judge as a bond violation. The atmosphere in the courtroom changes noticeably. The discussion moves away from explanation and toward potential sanctions. A single earlier choice has now affected the overall direction of the case.
There's no way that after a couple hours you can't go a little bit. So I'm going to find Ms. Paul based on your number one, that you told me that you smoke marijuana. You told the man in the back, the drug tester, that you smoke daily, and that you used alcohol also yesterday, which alcohol's I'm not so worried about unless you're driving, but obviously using marijuana is a violation of the law, which means it's a violation of your bond conditions.
Okay.
And so see something real quick. Your current bond that you. I need to take a look at probable cause affidavit. Give me just a minute to get you more information about you and your case, and then I'll decide what to set your new bond at.
Miss West, can I say, I know that I'm going to jail today, that's fine, but I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation. Well, because the girl is still harassing me.
Have you called the cops?
No, but I have the proof of her going to my job recently, letters from my job and her job.
All right, just hold on. You're going to need to tell all that to a lawyer. That's. You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right, so based on the limited information that I have,
Jeez.
I'm going to again find that you violated the conditions of your bond and in cause number 25 DCCR 175.
The proceeding now reaches the bond determination phase. Judges weigh factors such as community safety, compliance history, and conduct displayed in court. When judicial confidence declines, bond amounts frequently increase, which can directly affect a defendant's release status. At this moment, the stakes are substantial.
To raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay.
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive.
Okay.
But it should be going down.
Okay.
So it doesn't just test whether you're positive or negative. It gives me an amount.
Okay.
And if it's not going down, then that bond's going to go up even higher. Do you understand?
Yes, ma'am.
If you don't get the drug patch changed every 2 weeks like you're supposed to, some people say, "Oh, it fell off," and they don't just fall off. Okay, so you need to make sure you have it on at all times. Get it tested when you're supposed to. If you make that bond, go back with the bailiff.
Okay.
Good. You're Robert Felix.
Yes, ma'am.
And come on up, ma'am. Let me get this pulled up here. Good. And let's see, this is 21-38610 and 21-38611. Mr. Felix is on probation in each of those cases, one for manufacturing or delivering a controlled substance and the other for felon in possession of a firearm. I received an administrative hearing from Ms. Shoppa Bradley, and in it, the request was to schedule it for a judicial review. So you were in custody and released December 18th, and the stipulation was that you have a GPS monitoring device with zero tolerance, and it looks like there have been several issues with that monitoring company, that the battery either hasn't been charged properly. Looks like you were out past curfew, January 2nd. on January 3rd. Also, claim that you have unstable housing, but you're supposed to be giving the information of which of the addresses you're staying at to your probation officer each day. Is that correct?
Yes, ma'am.
So what's going on?
I let her know the address I'm staying at. Anytime I was out past curfew was because of work purposes. I was doing that. I gave her the receipts of proof for that. I have a job right now at Sparkling Image, looking on my seated
At where?
Sparkling Image Wash Depot, and I also DoorDash. I've been on this monitor for 5 years, Judge. I paid over $14,000 since 2021. And the monitors wasn't really hindering me doing what I need to do. And
Well,
like I make the curfews, I lost my house and everything. That's
well,
why
here's the thing. This was your, hold on. For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming at that angle is not going to go well. Okay. You've had some issues. You were here and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the...
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away, of what he needed to take care of. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night, I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge, but I've spot checked, and he is he's doing it. He's going to school, but this monitor is not acceptable way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I do.
Okay. All right. And here's the thing. It sounds like, Mr. Joseph, if you had...
A noticeable shift in tone follows. The judge transitions from focusing solely on penalties to emphasizing responsibility and corrective action. This demonstrates that probation hearings are not limited to addressing violations. They also provide an opportunity to show improvement and accountability. The critical issue is whether genuine progress is being made.
Showed up the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for years. I've been doing everything.
You've been coming to, what court you're supposed to come to when it's my day for you to come to court, because you've been coming since you've been on the probation. So that's not, if there's an issue here where you're supposed to be.
I just followed the last directive order. They sent me to Port Arthur.
Who's they?
I had the info.
So here's the thing. Things are going kind of well for you. You probably should quit coming up with excuses. Okay? Because it's probably one of my number one pet peeves. It's just to keep coming up. Just take the personal responsibility. Went to the wrong place. Should have asked a bailiff. You know where the 252nd District Court is. You know the judge that's you're on probation for. So I'm going to, it sounds like you've got some really positive things going on, and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil, but you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult because if you're changing places, you got to keep telling her. But keep doing all of that. You're going to be fine. Okay. So I'm going to I will allow the order that the GPS monitoring device be removed. That makes it all the more important, though, that you stay in touch and she knows what you're doing, where you are, and all of those things. Okay. All right. You're free to go. Thank you, ma'am. Thank you.